Let's take a look at the facts of this case. The claimant in this case was an 8-year-old boy. Him and a friend had climbed down an uncovered manhole. The manhole was uncovered because engineers had been undertaking work on some underground telephone lines, and overnight the hole remained uncovered apart from a tent was placed over it with paraffin lamps surrounding it as a warning sign not to enter. The claimant and a friend climbed into the hole, and as they were doing so, they managed to knock one of the paraffin lamps over. Rather than burning themselves with the paraffin lamp, as may have been expected, the paraffin lamp fell, and then there was a large and severe explosion as a result of the lamp smashing. This then caused very severe burns to the claimant. The question in this case was whether that exact chain of events was foreseeable, and therefore whether it should be subject to the principles of remoteness of damage. The outcome in this case was that the defendants were found to be liable. They owed a duty of care because of the danger that they had created by leaving the manhole uncovered, and had breached this by failing to ensure that it was safe and could not be accessed by young people, as it may act as an allurement. In this case, they held that the defendants were liable as the damage was reasonably foreseeable, because some harm was foreseeable in these circumstances. It was held that the test of reasonable foreseeability under remoteness of damage does not require that the precise sequence of events needs to be foreseen. Although the accident was a variant of the foreseeable, the accident was foreseeable nonetheless. This is therefore our general authority for the fact that within the principles of remoteness of damage, the test of reasonable foreseeability does not demand great precision. In cases such like this, they held that where there is such a danger, which acts as an allurement to young people, it is hard to predict and foresee and pinpoint exactly may occur. But in a scenario such as this, it is foreseeable that harm will occur, and it is not required that the exact shape of disaster that will arise be foreseen. In this scenario, it was held in the judgment that the accident was a variant of the foreseeable and therefore fell within the principles of remoteness of damage.